Are you ready?
I am ready, Judge.
Come on, Mr. Francis.
How are you?
Hey, what's up? Sorry to keep you waiting.
No, no worries. Kyvon Rogers still.
Roger.
Here, he's in the box. We're addressing the BDR this morning. So on Monday, this past Monday, there was a BDR issued against him saying that he tested positive for marijuana. However, Mr. Rogers was given bond conditions on 5/15. He reported for testing as instructed on 5/19 and tested positive. We would expect that.
That's not the problem right now. That's not the problem right now. Come up, Mr. Rogers.
He was then again requested to come on 6/1 and he tested positive as well. That's 14 days after.
That's not the problem.
Okay.
The problem is that we gave him a curfew and he's out at 1 a.m.
And I understand that. And I spoke with Mr. Rogers about that. He's telling me that he lost his charger. He fell out of his backpack. He's looking for his charger. His ankle monitor is beeping and he looks in his backpack, can't find his charger. And he goes back to the last known place that he was, which was 2 blocks from his house. He's running back
At 1 a.m?
At 1 a.m.
Right. No, it's your third bond violation, man.
Judge, I've asked pretrial services to find out, to confirm whether his device was beeping.
I don't care that it's beeping. I don't care. I care that you're out in the middle of the night and I told you not to go out in the middle of the night. It's your third bond violation. You're going to jail. I'm revoking your bond. No, it's your third time and you're out at 1 a.m. Wait until the morning to go look. You know you're on bond. You know you have conditions. It's your third bond violation.
If his ankle monitor would have died, he would have been in bond violation anyway, Judge.
I'm sorry that you lost it. Take better care of it next time. But really, it's the third bond violation. You're out at 1 a.m. Sorry, you're going in. It goes with you.
Thanks, Judge.
Thanks, Mr. Friend. This device has a dead battery now. This is Avila. It has a dead battery.
I think that the officers is check see any updates this morning.
You were ordered to get a GPS monitor and you have not kept up with that monitor, Mr. Avila. And I have seen now that the battery is dead and you are not being supervised in violation of your bond conditions. You're on deferred for a very serious case upstairs, and yet in a week or yeah. Sorry, you leave me no choice. It goes with you. I'll appoint your lawyer now, Mr. Avila, but dead battery, dead bond.
I'll pick up one side.
Sorry, bud.
We've taken extra things since last week.
Yeah, it's
Council code
5,001. All right.
This does look like a case that's a little bit of a gout, whether it has some benefit there or not, we'll see on. I'm going to explain what happened her last, her second bond violation, if I may. I know what they are. Case of free trial. It says the alcohol can't be confirmed. She added this that she had Hamilton's case. On a personal note, I know the families through my wife's church. I had them in office on Friday. There are some inpatient facilities, families going to look at like we're in. The offer has been made, and it's not that offer, but I would like to give my manufacturer now a little more. There's not a real witness and what have you to do my due diligence job. I'm going to ask the court not to take any action on the allegation. This recent one, maybe a couple of weeks. To see if there's facilities which will help my position negotiate with the prosecutor possibly. There's other things that she's gone to since Friday. She's attended 2A meetings. She's actually got a chip. She has a book with sponsors' names in it. She's done everything I've instructed her to do. I know that doesn't make up for the possible alleged.
Come up. Come up. Mr. Thering. you know,
Getting her license up to date and specific, she hasn't, it's not driving, it's literally yes or no, sir.
I, what's the last name again, please?
It's a hyphenated Alvaro.
That's,
We are-
I appreciate your tenacity, but this is a fourth bond violation report, Mr. Theron.
The other two were in BACs, right?
It's a fourth bond violation. For some reason, we are not getting your attention.
No.
Stop. It doesn't matter. It is a fourth bond violation. We are not getting your attention. As much as I love you and appreciate you, Mr. Theron, this is a fourth bond violation. And it's not fair to everybody else because anybody else that has 4 bond violations, that's it. It just doesn't matter. And I've told you since the first violation that it is no tolerance going forward. So you really have tied my hands because if I let you go now, I'm telling you this behavior is okay when it is certainly not. When my child does something wrong, come on, buddy, I told you not to do it. He does it again. Come on, I told you I'm going to spank you next time. And then he does it again, and I don't spank him. Come on, you've done it twice, and then he does it a third time. And then he does it a fourth time. What is the value of that? Sorry, Dad. What is the value of that? Sorry. We are here on a fourth bond violation. You understand? Right. I can't continue to do it. Somehow I have to get your attention. And now I'm just, the only other thing I have left is just to set your bond high. Because that's I have really, truly bent over backwards not to put you in jail. Sorry.
Yeah, can
She's
we
going in.
work the case out? Since I told you that also mistake. And give you 2 months for probation.
Whatever you want to do.
Okay.
The problem is that if you get on probation, because I don't know what's going to happen, but if you get on probation and you think that it's going to continue like this on probation, we have treatment facilities in the jail that are at a minimum 9 months to a year and a half, depending on how well you respond to treatment. Do you understand?
Yes, you're on.
Okay, please. So it's up to you, whatever you want, but really, it's not fair to everybody.
The way you phrase it, absolutely. Yeah. I mean, obviously there would be explanations, but that's what it is.
After a fourth, it's just
I think
whatever you want to do. I'm really, you have my blessing with whatever you need, really. I don't think it, time served, I don't, but,
But we looked at some inpatient facilities. I think we're going to do.
that's, I think, more before she graduates to something where you really, right? Yeah.
Thank you, Judge.
Yes, sir. Thanks. Okay. Mr. Henry,
Morning, Judge.
good morning, bud. What's up?
Amy Mills on docket.
Okay.
You said for bond forfeiture, they have not heard from her. I've spoke to family members who have also tried to agree to contact her, but I have not spoken to her directly. And I'm pretty sure I was speaking to you as well because she was released out.
So on Friday, Amy Jones reported to our office and
Sure, I remember they took her in.
they did not take her in. So
What?
when
She
I,
had 2 felony warrants.
when I talked to the warrants unit, I talked to a supervisor this morning because when I looked at her file, they actually dismissed her and told her to go to court. And I asked,
I just don't understand. I don't.
they said that they're looking into it right now, and I told them, well, she never reported to court on Friday, and so, right now they're looking into the situation of why she was dismissed from our office with 2 felony warrants, and so,
I just don't understand. I mean, it's like we're working against ourselves, really. I don't know what to tell you, but I can't, I'm going to revoke her bonds. You know, she is supposed to maintain in contact with you. She's not done so. She has 2 felony warrants, really. Okay, all right. Do you want to stay on? Do you want to withdraw?
I can withdraw that.
Okay, sure. Counsel,
Yes, sir.
hey, good morning. Okay, what is the last name again?
Travis.
Oh, he picked up a new felony case. Oh, no. So tell me, he's a violation of a protective order. Is this the same, in the felony case, is the same complaining witness as in this case?
No, George, they did,
So what happened in this new case, if you don't mind?
felony, on 2/17/2026, the officer in his town places observed a motor vehicle traveling,
Reset. Oh, they're resetting the date?
traveling at a high
Hold on.
rate of speed. Past the officer, a traffic stop was conducted, driver's license check on defendant. Found an active, protective order with CW, the passenger of the motor vehicle. Defendant advised he knew there was a,
No, not in our case, in the felony case.
yeah, this is.
This is the felony case?
Oh. Sorry.
Why she looks your night, so, oh my God, right? Accusing him of. Making public their public,
Accusing him what?
making public, transcending their name, pictures.
So making public nude pictures.
Officer investigated an unlawful disclosure of internet visual material. Officer spoke to the principal who stated that there was a photo of a current student performing oral sex, which surfaced on Instagram page of the school on 4/10/2026. CW stated that she was advised by several students that an Instagram page, quote unquote, DIHS page confessions, contained a post of a picture of CW having oral sex with defendant Chavez, her ex-boyfriend, while home alone with him, and he had recorded it. CW stated that around November 2025, they broke up. Defendant Chavez found out that she was friends with defendant JJ and sent him a copy of the video thinking her and defendant JJ were in a relationship. CW stated that they made a police report of the incident, but did not have a case number, nor did they hear back from the police department they made the report with. CW stated that a picture from the video was posted on social media and she was told defendant and he was the one who uploaded the photo. CW stated that defendant JJ could have sent the photo. Defendant JJ gave a non-custodial interview where he stated that he was not aware of how defendant Aguilar received the video, and as he did not share it with him, defendant JJ stated.
I think we're good. Yeah, we're good. Mr. Chavez, I'm going to find that you violated the conditions of this court. You are a danger to my community. I'm now revoking your bond and you will go to jail. I'll set the bond at 10,001. Okay, you will go into custody now.
Thank you.
Thanks. Good morning, Mr. Petoniak.
Good morning.
Happy Wednesday.
What's that?
What's that?
Good morning, Mr. Fleischer.
You all right?
Yeah, I'm okay.
Yeah, cool. Yeah, have fun.
Yeah. Oh,
Is it old?
I'm being told I need to approach.
Who is it?
Silver nail.
Where's Mr. Silvernail now? Come up, Mr. Silvernail. I'm sorry, Mr. Petoniak. But It has come to my attention that you've not picked up yet another case. You now stand charged with violation of a protective order. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you.
June 14, law enforcement responded to a welfare check in Harris County, Texas. When they made contact with the complainant, she was visibly shaken. She indicated that the defendant knocked on her door and said that he had been in a motorcycle accident and needed medical attention at 1:30 in the morning. Defendant entered the residence and was ordered to leave by the complainant, but he refused. He entered her bedroom and attempted to hold and hug her while she was covered in a blanket. The complainant advised that the defendant did not want to let her go and was trying to force her to hold him. Did not leave until complainant contacted law enforcement. She began receiving messages from him in which he threatened to cut off his arm, which he had previously injured earlier in the day. The complainant advised that she had obtained a protective order against the defendant on April 29, 2026, and he was identified by his driver's license. Officers confirmed that there is a valid protective order currently in place for this defendant, prohibiting him from coming within 200 feet of the complainant and the residence where he was located. The protective order further prohibits him from engaging contact directed towards the complainant that is likely to annoy, harass, and abuse, and harass her.
Okay. So we did order him not to go back to this location, correct?
And he has currently an open harassment charge. I'm sorry, that one was dismissed 6-4. But he does have a protective order in place. We do have that. And then he had that deferred for the assault family member that he pled to in 2024. I was double checking to see if it's still in place.
I don't think a motion's been filed on that yet.
No motion has been filed, Judge.
Can you-
Last time.
It has been filed.
It's in your queue. Okay, there you
I'm
go.
s- I'm s-
Last time he was here was 6/4/2026, where we amended his conditions of community supervision and extended him from 1 year on 6/4/2026. And this charge happened
Mr. Silvernail,
6/14/2026.
I'm now signing a motion to revoke your probation and a warrant will issue as of this very moment. And let me tell you something, and I want you to hear me loud and I want you to hear me very clear. The Texas Constitution does not allow me, but in extremely limited circumstances, to have a hearing to hold you at no bond. You are now at that stage. You are charged with violation of a protective order. If I put conditions on you now, you violate these conditions, within 3 days, I can have a hearing to hold you at 0 bond, and I will do it in a heartbeat. A felony choking case, a harassment, you're on deferred for an assault, and now you've picked up a VPO. The next step is you violate conditions I put on you now. I will have a hearing to hold you at no bond. Do you understand me?
Yes, sir.
As it stands now, you are going into custody at this moment. I'm filing a motion to revoke your probation, and now we will have a hearing to determine if you violated your probation. So
And Your Honor, he made a $20,000 bond on the new case. He does have a bail bondsman on the way up.
no, I don't care. This is the 4th case against the same complaining witness. He's on probation. There's a protective order, and yet it's over, and it's over. Clearly, there's no non-financial conditions we can put to ensure that he's not going to violate conditions.
He does have an ankle monitor on this morning that he was in custody for 2 days when he picked up this case. So he was arrested Sunday or Monday. He made bond yesterday. So it was 2 solid days. He does have an ankle monitor on now. So considering the high amount of the bond he has already made and that the ankle monitor is in place, I would ask that he be permitted to walk through the bond, or a bond is set.
The bond is set at 10,000 now. On the motion to adjudicate.
Understood.
Well, no, has he violated conditions before?
So when he was placed on the deferred originally, we took that plea 5/21/2024. he picked up that harassment charge.
Yeah,
And so then we dismissed the harassment.
I'm sorry. While he's on probation, he picks up a harassment case. And we were working toward finding a resolution to be amenable to everybody. And now he's picked up another case. I'm not going to let him do a walkthrough. It's not reasonable. You know what I mean?
Understood.
It's
So,
the second time he's picked up a case while he's on probation for an assault.
understood, Judge. So the bond amount is $10,000 on the motion to adjudicate.
Yeah, what's reasonable considering everything?
It's 10,000 is reasonable, Judge.
It's 10,000 now.
So.
That was when he picked up the first case, it was set at 10,000. Now he's picked up another case.
So, Judge, in light of the fact that he already made a $20,000 bond on the new case, would 15,000 be reasonable?
Judge, honestly, I fear complainant.
Really, we're just not getting through to Mr. Silvernail. Mr. Silvernail does what he wants to do without regard to. He could, just because he has an ankle monitor, doesn't restrict him from going to the house. He could theoretically leave here, go back to the house. And that's the fear that I have. He does whatever he wants to do, to hell with the bond conditions, and not 3 cases, 4 different times in custody have made a difference, you know?
I understand there was a lot that happened in the past. I've communicated the expectations of the court with my client, and he stands ready to comply with your expectations as stated.
But
Judge, I can say that it looks like he pled on 410, picked up that charge. He pled in 2024, he picked up that harassment on like 3/30/2026. He amended his conditions to extend it for a year on 6/4, and we're back here 10 days later on a new charge.
I'm setting your bond at $50,000. I don't know how else to get it to really have you understand how important and how meaningful bond conditions are. Everything that we've done today, really 10 days later on yet another case. As much as I love you, Mr. Petoniak, the problem is it's not you, it's him. And we're now yet again, 10 days later. I really have I mean, I really truly don't think that there are any non-financial conditions. And let me tell you, I told you, Mr. Silvernail, if you go within 1,000 feet of where this person lives, works, breathes, I'm going to have a hearing to hold you at 0 bond. Do you understand?
Yes, sir.
You were not to consume alcohol, illegal drugs. Do we know if alcohol played any part?
She did not indicate, Judge, that she was impaired on this occasion. Let me just double check the other ones.
I mean, do we put a device on his ankle?
There's one.
No, a scram. Yeah. Because I don't know if drugs or alcohol are playing a part in the choices that are being made, you know? A lot of people seem to make choices when they've consumed, and I don't know if that's part of the issue.
Judge, she did not indicate anything relating to substance abuse. She did indicate that he had PTSD, which causes him to be emotionally abusive and angry, but nothing in relates to any drugs or alcohol or anything like that, Judge.
My client indicates he's a teetotal.
So what?
Teetotal. He doesn't drink.
Oh,
There's not no indication from
I
that.
mean, I'm still going to order just no consumption of alcohol, no consumption of illegal drugs. You're going to be tested on a weekly. I don't know if you're going to bond out, but if you do, you'll be tested weekly so that we know you're not using. And do me a favor, let's fast track this
Yes.
because I'm now going to set you for a hearing in 30 days on this motion to revoke your probation. And we're going to decide you're looking at a year in jail. Do you understand? But when we have cases that are entirely way too much drama, the longer we wait, the worse it is for all the parties involved. It's just so Please do your diligence to get everything as quick as possible, and then we'll go from there. He goes with you. Nick, I'll talk to you in a second, but I want him to go back.
Yes, sir.
Can we go back?
Yes, sir.
Come on. Hi, please.
I'm here for Mr. Morales,
Okay,
and I'm covering for his attorney Stephanie Alonso. She, got her times mixed up. She's flying in from out of the country and is actually arriving later today. So she asked me to cover, for this bond violation, report. She asked if the court would be able to roll into Monday, as she will be here for his Monday setting.
I'm not going to be here at that point, and so is the defendant here now?
He is, Your Honor. He's here in the jury box. Would you like him to come up?
Please.
Okay.
The one thing I told you not to do was what? Right. You've now picked up a new case. Not only that, I ordered you not to consume alcohol or illegal drugs on your first case, and you now picked up a DWI. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Do you mind reading me what happened on the DWI, please?
Yes. On June 12th, 2026, officer observed the defendant's vehicle, driving in lane 2, and the defendant then began to swerve and failed to maintain a single lane, swerving into lanes number 1 and lanes number 3. The officer then initiated a traffic stop on the defendant's vehicle, and observed the defendant had hypertensive eyelids, slurred speech, bloodshot eyes, and a moderate odor of cannabis coming from the vehicle. The defendant advised to smoked marijuana around 1 hour prior to the traffic stop. The defendant then exited his vehicle and was changed. Standard right tests were conducted, 6 out of 6, HDN, 5 out of 8, walk and turn, very 401 stand. And a breath test sample was gathered with the results being 0.00 and 0.00. But at that point, the officer had formed the opinion that the defendant was under the influence of depressive stimulants or cannabis.
Okay. Mr. Morales, I'm going to find that there's probable cause to go forward with your case. You will be tested 40 days from today. If you test positive for anything, including alcohol, including marijuana, then I'm going to put you back. I'm putting you in jail today because you picked up a new case. I told you not to pick up a new case. You picked up a DWI. You will go to jail now. At some point, you're going to probably be let out. But I'm telling you now, you will be tested 40 days from today. And if you want to continue to play this game, we will. Every time, double, triple, quadruple, quintuple. Do you understand? Okay.
And then the other case I have was Mr. Samuel Henderson, who's in jury box. I was appointed last week. He got a DVR because he failed to get his device.
Did he get a device?
Oh, is this Mr. Hernandez?
Henderson.
Oh, sorry. Henderson, he did not.
Mr. Henderson, come up.
He told me that,
It don't matter. It just, he didn't get the device.
okay, well, I did the court to know that he did just get hired at IH.
Great. He didn't get the device like I told him to. I get it. Mr. Henderson, we have bond conditions for a reason. This isn't about what you want to do. You have bond conditions. We place bond conditions on for a reason. This is your 4th case within 3 months. No more. I'm sorry. You're going to jail.
Yes, sir.
He goes with you. Hi. Come on up. Good morning.
I'm Mr. Giovanni Fuentes. Who has a bond violation for picking up a new charge.
Okay. Fuentes, come up. Does he still have an open felony warrant?
Yes.
Okay, I have to take you into custody. You have an open felony warrant, plus you picked up a new case with us. So he's on. You are now charged with violation of a protective order. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On June 13th, 2026, officers dispatched to a servant/unknown weapon call at approximately 1:13 a.m. At a residence in Harris County, Texas. The officer spoke with the complainant, and the complainant stated he was unaware of bond conditions, but was aware of the protective order, but did not know that it expired on June 13th, 2026. Complainant stated the defendant came home, they were having a verbal argument. Defendant then pushed him and struck him in the face an unknown number of times. Complainant had red bruising on the right side of his face, right hand, and red marks on both knees. The complainant said he wanted to press charges. The defendant stated that the protective order was no longer active, but he was not aware of the bond conditions. The defendant stated he got into a verbal argument with his boyfriend due to another man driving the defendant home from work. The defendant said he was trying to get his belongings when the complainant witness struck him in the face with a closed fist, run a number of times. The defendant stated he defended himself. The defendant had injuries including bruises to the left side of his face.
This is the same complaining witnesses in the assault,
Yes.
same complaining witnesses in the mischief case as well?
Yes.
Yes.
Mr. Fuentes, let me be clear to you, and I want you to hear me loud. You're now charged with violation of a protective order. I'm putting a whole host of conditions on you. You violate these conditions, I will have a hearing to hold you at zero bond until these cases are over. Do you understand? I'm now putting you in custody and I'm raising your bonds to $20,000 on each of your cases. I don't think there's any non-financial conditions that will protect our community. The only thing I have left is a high bond. And I don't know if you're going to bond out. If you do, you violate again. This time it will be a hearing at no bond. Do you understand? You are not to have any contact with the complaining witness and you will get a GPS monitor. You're not to go within 1,000 feet of where this person lives or works. You are not to consume alcohol or illegal drugs, not to be in possession of any weapons. Veronica, do you mind the tag so that it allows the complaining witness to know? You are bond denied on your felony now as it is. I don't know if you will be getting a bond there, but upon your release, you will get a GPS monitor. You will also get a curfew of 7 p.m. to 7 a.m. So you are not out in the middle of the night. I'm warning you, don't endanger my community. Do you understand? Okay, I need him to sign conditions and then we'll, okay. 20,004, because it's this fourth case. All four against the same complaining witness, really, or except for the, assault of a peace officer. But I guess just let me know. I mean, he'll auto-populate for Monday, or he'll probably go to felony court Monday. So I don't know, maybe Tuesday. 20,003. And then just let me know. Okay, thanks. Hey, Mr. Newley.
That we have a one violation and the translator is here. Mr. Garcia Mendes.
Okay.
Manolo.
He was ordered to obtain a portable device and he never did. Did he get a portable device?
He has not, he referred to our office.
I ordered you to get a portable device. That was your bond condition. Did he get it?
He has not gotten it.
Let me interrupt. What happened was that according to him, he went to the place. They even sent him an email and told him to come back in 4 days. He got the other scripture. When I spoke to him, he told me that when he went there, they circled his place and counted 1, 2, 3 days for him. And they displayed the same thing to him, but they told him to come back in 4 days. And I asked him, why did you not report the first day they told you to report? According to him again, he said nobody told him. That's what he explained to you, correct?
We told you. Our pretrial service officers told you to go report that day. So you failed to go report yourself. I don't know what to tell you, Mr. Manolo Garcia, but
Really didn't understand the English.
you seem to understand now.
The court interpreter was used. So he was spoken to in Spanish.
I'm sorry, Mr. Noli, but I mean,
No, I'm just telling you what she reported to you about it. You were there, wasn't it?
we ordered him to get a device
Yes.
that day. He just didn't go.
He did not do it, and I asked him why. And he told the translator that he did not understand the instruction. That was what was concerned. So I told him, if you did not understand the instruction, why did you not ask them before you did it? He said that when he called them, they told him to report as soon as possible. And that was why he came on a Tuesday. That's what he told him.
Yeah, I'm sorry. I have to revoke your bond. You will be going to jail.
Thank you, Judge.
I'm sorry, Mr. Noli.
Okay. What's your turn?
I don't have one anymore.
What is your last name?
Washington.
Should I have docket, Judge?
I have a text telling me to come today.
Looking for a blood test? Do you have your paperwork?
No.
Do you have any paperwork with you?
No. Sorry. 11/29 gig. It's the 18th. Yeah. I got a text yesterday telling me.
Okay, it's there.
Yes, pretty sure I was gonna do it as much.
Go take a drug test.
No, let me see, or give me 1 second to wait. Do you have the case number? It's 260691 Yeah. Judge, do you remember this case number? It's
Ma'am, you gotta come up.
260691.
You have a warrant for your arrest. I have to take you into custody.
The lawyer that.
Stop. You have a lawyer. I am not allowed to talk to you. All I know is that you got a warrant for your arrest. And so I have to take you into custody. We'll reach out to your lawyer now, but
No.
stop. I cannot talk to you. You have a lawyer. I'm just telling you, you have a warrant for your arrest. I have to take you in and I'm not allowed to talk to you without your lawyer. So you do have a lawyer. Your lawyer has not withdrawn. I had never signed the motion to withdraw. So you do have a lawyer as of right now. So we'll reach out to him right now. Hey, so we just got Miss Watson.
Yes. She has not fulfilled the contractual obligations.
I get it, but I'm putting her in custody now. I'm not going to take you off now so that she's in custody without a lawyer.
Oh, okay.
So what we can do is she'll appear on Monday.
Okay.
And then if you want to, I guess, either zoom in or come in.
Sure.
I'm not going to be here. Judge Singer will be here. So whatever Judge Singer wants to do, I'm okay with, you know.
Court does call the case is Latipo versus Robert Shelberg.
We are.
Assistant Public Defender to Victoria Ruby on behalf of Mr. Robert Shelberg. Mr. Shelberg, state your name for the record, please.
Robert Gerald Shelberg.
Oh, thank you. Your Honor, we're going to ask for an adjournment. I think the court should have that. Is that right?
I do, Ed. Surprise.
Asking for an adjournment, Your Honor. The people provided us with some information that I need to speak with Mr. Shelberg about.
You may.
Shelberg has been calling the victim's number that we have been trying to get. In these calls, he says things like, it was, I'm so sick, I can't even take it. You gotta get that taken Kara, you gotta be here on the fourth to rebut it. You have to rebut it. You understand? You have to complete it. I'm going through it so bad. I've never went through withdrawals this bad in my life. You know they're going to give me a year. I'll never put you in this position again. I promise. I promise we're not going to do this again. We're getting married. But if the third sticks, I'm going to prison. If you're there and you say he never hit me, he never put his hands on me. And I mean, it goes on and on. The forfeiture of the potential and intention to charge in this for just these calls alone. So at this point, I'm going to be asking for his phone privileges and text privileges to be revoked, given that he's been contacting the victim numerous times and telling her to change her story and to not come forward.
What is his bond currently set at?
Your Honor, I have his bond currently set at $10,000 cash surety on the ED case and $25,000 cash surety on his controlled substance possession case.
Anything you want to say?
Nothing, Your Honor, until we're able to get those calls and review them for ourselves.
This time defendant's phone privileges and texting privileges are hereby revoked. I'm also, given the substantial nature of those calls, the content of those calls, defendant's bond is also ordered revoked. Defendant, go back.
Is that bond revoked on just the TV case?
It's revoked on both cases because he's not following.
Please.
I didn't give one to 18th. Court calls the case People versus Gregory Huff.
And done on behalf of the people, Your Honor.
Assistant Public Defender Zach Vinue with and on behalf of Mr. Huff, who approaches. Your Honor, we were requesting an adjournment in this matter, and there's also a bond issue to address.
Yes, I will adjourn the matter to the 25th, 2026, 9 a.m. as to bond.
Bringing my attention that while Mr. Huff was in custody after he had been arraigned, he was arraigned on the 23rd. These calls were made on the floor. Her listed number. In these calls, I had a couple of concerns, given that he was saying, I need to get out of here, I'm going to lose my job. They want me to get out. So I had concerns given the nature of these calls. And the fact that there was contact being 3 days after he was arraigned with the victim.
Your Honor, Mr. Huff would admit to this violation. He would admit to calling the witness while he was in custody, or the complaining witness while he was in custody. We would ask to be heard as to bond and or sentence.
All right, Mr. Allen, go ahead.
Your Honor, Mr. Huff does admit to these violations. He was in custody for 6 days from May 22nd until May 28th before he bonded out. During that time, Your Honor, he did not have any of his medications with him. He did not have his blood pressure medication. He did not have his heart medication. So his blood sugar spiked to dangerously high levels. He stated to me that he was not in his right mind. He was it was in a situation where his decision making was affected by his health conditions being exacerbated. So he stated that once he has been out, he has compliant on bond. He's on a tether. He is staying with his stepdaughter, Your Honor, and there's been no tether violations or anything that I'm aware of. Additionally, Your Honor, he has these allegations were our office found out about them this morning. I informed Mr. Huff of the possibility of him being remanded today. He did not run. He did not flee the courtroom. He sat right there this entire time, knowing that he could be brought into custody, Your Honor. So he's requesting another chance, Your Honor. He understands the nature of these charges and that he will have no contact whatsoever with the complaining witness. I believe she is here as well today, although I don't know that she's going to speak or anything like that. But and then additionally, Your Honor, he is very concerned about losing his job. He has severe health issues. His wife, this is the complaining witness in this case is his wife of 20 years. She also has health issues. She has cancer, is my understanding. And so he is worried that if he loses his job, they will both lose health insurance. And so for that reason, Your Honor, we're at the court's mercy. And then lastly, Your Honor, if you were to remand Mr. Huff into custody, he would be requesting just a day or a few hours so he can go and get his medication so that this situation does not happen again while he is in custody. And then lastly, Your Honor, he has been attempting to go to community corrections and test. He was arraigned over the weekend by Magistrate Wang, and it appears that there was some issue with getting the community corrections test over. So he has been trying to go there. He has been twice. He has called. And as of right now, they stated that they did not have an order. So if Your Honor were to allow him to not be placed into custody, we would request that an order be sent over to community corrections so that he can test. Thank you.
Send this out to the 25th. I don't need any response to that from the people. Depending on having admitted to the violations, I'm going to send it to 10 days. I'll give him credits, but at this time, depending on his room.
Thank you, Your Honor.
Courthouse case, the people versus Douglas Hill.
Good afternoon, Your Honor. Jake Miller, P58658 on behalf of Mr. Hill on one of the matters.
And Assistant Public Defender Zach Binney with on behalf of Mr. Hill on the matter ending in 1363.
Your Honor, if I may, I had prepared an adjournment to place into the file as I was awaiting some discovery on the case I was just assigned. When I was speaking with Mr. Hill, I forget if it was Monday or Tuesday, he indicated that his bond report was not going to be good. And we had some discussions about that. I did receive the report Wednesday, and Mr. Hill has shown up today. He understands that the court's probably going to be in custody. We just request that he be allowed to complete any kind of drug treatment program in the jail. And if the court in the future, when appropriate, would consider a residential treatment program for Mr. Hill. He's been trying to get into it while out on bond and just can't get into a program.
Your Honor, we would second that that request, and then we would also second the request for an adjournment to keep moving. I will also just note that Mr. Hill, I had a discussion with him. I did not know about the bond violation report until yesterday. So I had received permission for him to appear via Zoom and sent him the Zoom link. And then when we let him know about the bond violation, he came here willingly, and he understands what's going to happen. So, or what's likely to happen. So just he is here. He could have not shown up, and he did. So we would ask that take him.
Well, what you mean is he could have made us find him instead of coming voluntarily. All right. I will adjourn both of these to, well, let me make sure on this one. I will adjourn both of these to the 8th, and this one. Not smart. To the 18th. He admits to the violations at this time.
Your Honor, I believe he admits to the violations as it's listed in the report. He does indicate, though, that the latest one that only showed marijuana may be impartial because of his roommates won't stop using. So I believe he was very candid with the investigator and the report and all the negative reports, Your Honor.
So the previous marijuana was him, and
Your Honor,
last one was a roommate or the people he lives with because she's an amoeba.
Your Honor, I believe if you looked at the first 3 bad reports, it was more than just the THC.
Oh, I know, but then the THC won't disappear. So I don't know how the last one all of a sudden becomes THC with other people and not him.
He has been very honest and forthright with me before I even saw the report, Your Honor, so I don't want to doubt Mr. Hill. He's indicated to me he's trying to get help, and I've indicated that hopefully through the jail he can get into the program and we can get him some help.
All right. Probable cause conference on both of these will be adjourned to the 18th.
Thank you, Your Honor.
Hang on a second before you. I'm adjourning both of those to the 18th. In the case ending in 1363, which I believe is the public defender's case, I'm going to set the defendant's bond at this time, $5,000 cash surety on that case. On the other case, also adjourning the probable cause to June 18th, 2026 at 9 a.m. The defendant admitting to the violations. At this time, the defendant's bond is revoked. You can send me an order for inpatient treatment. I'll certainly take a look at it. At this time, defendant's remanded.
Thank you, Your Honor.
Court does call the case, People versus Amanda James.
Assistant Public Defender David Fleischer on behalf of Ms. James.
Yes, sir.
Ms. James, can you tell the judge your name, please?
Amanda James.
Council approach, please. Or what council approach? Record to reflect we had a bench conference in this case. I shared with council some information that, ma'am, you've been using cocaine within the past day or so.
No.
Oh, so if I refer a test, are you going to really come back clean?
Yes, I am.
Really?
I am.
Why'd you admit to certain people over at another court that that's what you did?
I called my probation.
I'll tell you what, before you lie to me.
I'm not going to lie, Your Honor.
Before you lie to me, because you already have started.
I'm not lying.
Why don't we put her over there? We'll let Mr. Lebo talk to her and see if she really wants to maintain.
A few moments later.
Court recalls the case, People versus Amanda James.
Ready to go to the Your Honor?
Assistant Public Defender David Fleischer on behalf of Ms. James. Ms. James, can you tell the judge your name again, please?
Amanda James.
And Your Honor, I believe Ms. James is now prepared to make a statement to the court.
She is. Okay, go ahead.
Yes, I did use 4 days ago. And when I was placed on probation yesterday, I was being honest with my probation officer and informed her that if this test does come back positive, it would be the only one.
So if you test today, you're going to be clean.
I am honestly hoping that it's out of my system.
Well, we all can have hope. If you test today, are you going to be clean? See, you're already on thin. Hang on.
I'm going to say no.
You're already on thin ice with me because you were about to lie. You were trying to lie to me. And so I'm going to ask you again. If you test today, are you going to be clean?
I don't think so.
You don't think so?
I think there will be traces.
Okay. So now you said it, but I want to make sure. When was the last time you used?
4 days ago.
4 days ago.
4 days ago.
All right. Tell you what, let's get it. We'll send you over, get a test. I'll pass it. Got to go over to community record. Get a test.
Thank you.
Okay, thank you.
Do you know where to go?
Yeah.
Okay.
And if she doesn't come back, it's a bench warrant, no bond, but go ahead.
A few minutes later.
Court recalls case People versus Amanda James.
Your Honor?
Assistant Public Defender David Fleischer.
Client here?
She does not appear to be here, Your Honor. I did place a call, but I did not get an answer.
You lost her?
Looks like.
And she did not test.
Your Honor, I received confirmation she did not check in.
That's unfortunate.
I guess if she was going to party before she thought she was going to jail, she might want to just keep partying because we're going to get her.
All right.
Bench warrant will issue for defendant's failure to appear at this, and my file will reflect the defendant was test, did not go and did not come back. No bond.
Thank you, Your Honor.
One eternity later.
Court calls case versus Amanda James.
And then go with the people, Your Honor.
Assistant Public Defender committee with my behalf of Mr. Tangible approaches.
You guys got to make sure to clear that way when transport's coming through, Mr. Lebo.
Ms. James, can you state your name for the record?
Amanda James.
Thank you.
Your Honor, this is the time set for a bond hearing. So, Ms. James, as you remember, as you recall last week, Ms. James was ordered to go to community corrections to test. She did go to community corrections to test. However, she does admit that she did not go straight there. She had to go home first. She went home to get the money to test, and then her mom wanted to stop at Burger King because she was hungry, so they stopped at Burger King. Then they did go to community corrections to test, but by that point, the no bond order was already in, so she was arrested from there.
Oh, yeah, I remember. We didn't get a test, did we? It was positive, right? Yeah. Okay, so I told her to go to community corrections.
And did.
She's here on campus. She left the building, and I remember her walking out. She said, "I'm going over." We sent another person slightly after her who got over there, tested, came back. We still hadn't heard from Miss James.
Ms. James indicated that her mom is here and does have the receipt of her going to community corrections the same day.
Oh, yeah, I know, but it was like she was supposed to go there and come back.
Yeah. Ms. James indicated that she did not, at the time that she was here today, or last week, she did not have the money to test, so she had to go home first to get the money, and then had to go to Burger King.
Where does she live?
1282 Medford Drive, Huron Heights.
So in this county?
Yes.
So when does it, 4 hours or 2 hours to go home, come back?
3 hours.
And then do that? And I don't know where the Burger King comes in.
It was not 3 hours, Your Honor. I was going 45 minutes.
Yeah.
I have my test.
For me that.
Please,
because we called over.
She said she called you when I got there, and I sat for like.
I know. She did.
Oh,
but she did get over and test.
She did come. Yeah.
Yeah. Then she left.
I did.
Then she, what, Your Honor, I apologize.
Then she left. She didn't come back over.
They arrested me there.
Yeah, I know. Why? Because we had to
said you put
warrant.
the warrant out. Yeah.
Yeah. And she tested positive for cocaine.
As I said, I possibly would. That was why you tested. That's why you said.
That is not what she said.
Your Honor, I told my probation officer that there was.
Oh my!
You recall?
Not what she said. Told me.
Your Honor,
I've not talked. I've turned around like that. I'm done. I'm done. Her bond remains denied. How much time do you want to put it over? I'm not playing games. I am not playing.
I apologize.
Think I am. If you're going to turn around and start smiling and doing all that, this is not a game.
I was just
bond denied. I'll set it over to July 2nd.
You're not even giving my information, Parker.
Keep talking. Court does call the case. People versus Daniel Keener.
Daniel Keener.
And then on behalf of the people, Your Honor.
Assistant Public Defender Donzie Lieb on behalf of Mr. Keener.
Mr. Keener, I need a camera.
Oh, I'm sorry.
State your name.
Daniel Keener.
And we're going to be requesting an adjournment in this case in order to receive some outstanding discovery.
Of your jail calls. Came to my attention, he called the victim one complete call after being arraigned, in which he was asking her to get some things in order for some keys, stocking things off, and then he called a different person and asked them to get in contact with the victim as well. I have concerns given that he had the one complete call, one that was not completed after, but he has two pending domestic violence cases with his victim. 1 in 14B, they're both arraigned at the same time. 1 in 14B for a DV, and then 1 here before Your Honor for felony DV. So I have concerns that he was contacting her after he was being told not to contact her, and that he has 2 pending domestic violence related cases with her at this moment.
And Your Honor, I did have a chance to discuss it with Mr. Keener. Mr. Keener is not going to deny making those calls.
So why is he violating bond?
What Mr. Keener explained to me is that he had a misunderstanding of his bond conditions. I'm not entirely sure how he has.
Not contact her.
I'm not.
How do we know? What confusion did he have?
I believe that what Mr. Keener experienced was that he was explained to that he could pick his things up as a civil standby, and for whatever reason, he believed he could call the complaining witness to coordinate that. I did discuss this with him in detail.
What?
And that absolutely no conversation is permitted.
He thought he had to, you know what? Where are you right now?
I'm in Detroit, sir. I'm in Detroit, sir. I was trying to get my keys.
Okay, well, that's about 45 minutes. We'll still be here. I want him here, and I want him to tell me that to my face.
Yes, sir.
So I'll pass your case. Don't appear by 4 o'clock. I'm issuing a bench warrant.
Yes, sir.
Thank you.
Bye.
A few minutes later.
Court calls the case, recalls case, People versus Daniel Keener.
That was it. We were on there.
Assistant Public Defender David Fleischer for Mr. Keener. Mr. Keener, could you tell the judge your name?
Daniel Keener.
And I did discuss the short system, Your Honor.
I came straight here.
What is it?
I came straight here.
Okay.
And I did discuss bond violation for this Mr. Keener. Mr. Keener would like to provide an explanation. Is that correct, Mr. Keener?
Yes.
And
So when I got arrested, I basically was just worried about my work uniforms and how to get my car. So I did make the call, and that was a mistake on my behalf. I shouldn't have done that, and I do realize that. Again, it was simply just to get my work uniforms in my car, and that was done. I haven't made contact. I haven't been in the area.
well, why did you have to make it twice, or at least twice?
Huh?
He's talking about your call to your cousin.
That was only one call.
There was one call directly from Mr. Keener from his kid. Someone else to get a hold of the family mentioning for binding.
Yeah. I didn't tell them to call her. They didn't have her number. She has my cousin's girlfriend's number and reached out.
What?
I didn't call my cousin to reach out to her. Like they already.
So why did they do that?
She reached out to him. She reached out to him to give him my keys so that he can grab my stuff.
Anything else?
Your Honor, I would just note that I think Mr. Keener understands. I had a long conversation with him. I think he understands the seriousness of the no contact order. I think he understands that he made a very severe mistake by violating it. And I think he understands that if he's fortunate enough to leave the court today, that this will be his last opportunity.
So you have one call, one direct call and one indirect?
Correct, Your Honor. And in the indirect, it says, and then I guess if you could tell the victim's name to call it to my job and let them know I won't be there again. So just calling them to have them get in contact with her so she can contact his job, and he's not supposed to be having contact with her because he has 2 domestic violence cases pending with her as the victim.
Mr. Allen. Why are you doing that? Because that's not even close to what you just told me before the prosecutor said what was said.
Calls that were made, one to her, one to my cousin. He doesn't have the information. It's just, can you call up to the job and let him know I wouldn't be there? I made
That's what you told me the first time.
I guess I didn't call up to my job for her to do that, but I did request for somebody to call up to my job. I just panicking. I was just trying to get done what I could get done.
Your Honor, I would just note, all these communications were about his employment.
They what?
All these communications were about his employment. And I believe that that's what Mr. Keener was most concerned with at that time when he made these poor decisions.
But I thought there was this indication about a civil standby.
Isn't that what you thought? You thought you could?
I reached out to Brian, who is my tether monitor person, but
This is the problem with the lie. Because you keep having to change your story.
No, it's the same. It's the same thing. It's not a. Sorry.
Anything else?
No, Your Honor.
At this point, the defendant's bond. Well, first of all, with regard to his bond conditions, I'll grant the request there to be no phone calls or text privileges. But I don't think the defendant should have been contacting in any regard whatsoever. I will adjourn this out 1 week to June 18, 2026, 9 a.m. At this time, the defendant's bond is revoked.